Ladies and gentlemen, Frank Policelli, who is Caitlin Connolly's attorney, on the line now. Frank, good morning.
Good morning.
You guys must just hate.
Straighten out a few things here because
okay.
People go off in so many different directions, including the Dateline show. Let me just set the record straight here because a lot of people have all these theories and facts, and nobody really knows what the facts are, including the district attorney who goes on Dateline and says, well, maybe she put it in her drink when she was seeing a patient. Do you remember her saying that on Dateline?
Yes.
Okay. First of all, the prosecution's evidence was that Mary was supposed to be going out to lunch to meet her mother. So if she's seeing patients in the morning, Katie would not put poison in the drink because she doesn't expect her to be having any lunch at the office that day anyway. Okay?
Right.
And if she sees patients in the afternoon, she had already, according to the prosecution's theory, been poisoned somewhere during her lunch break. Okay?
Right.
Which means that she would have had to have been poisoned at the office between 1:15 and 1:30 in the afternoon when nobody else is in the office but Mary and Katie. And if Mary's mixing her shake, then that means that she would have had to put the poison in her shake at the same time she's mixing it, okay?
Right.
That's the prosecution's evidence, all right? So their theory, or they want people to guess, speculate, conjecturalize, which brings me to the other point of people saying, well, why didn't she take the witness stand? Why didn't she take the witness stand?
That was earlier.
Here's what non-lawyers got to learn to understand, okay? When you've got an entirely circumstantial evidence case where there's insufficient evidence to get to a jury as a matter of law, you have to have a record of the trial court for an appellate court to review in the event that the trial court does not go your way, okay? Once the defendant takes the stand, then all of your issues on appeal on circumstantial evidence is gone. Because they're going to say, well, the defendant took the stand, they didn't believe her, you lose, okay?
Yeah.
Well, this case here has a tremendous record for appellate review and sufficiency of evidence. You don't know when, where, how this woman ingested the poison.
Right.
I don't believe they can prove a murder even took place, okay? Now, you get on Dateline, and there's nothing on Dateline of my cross-examination of Nelson. There's nothing on Dateline of my cross-examination of Martino. And most importantly, there's nothing of my cross-examination of Adam Yoder, okay?
Nelson is the investigator, right?
Nelson's the investigator, yeah. Who claims that she lied when he was interviewing her, okay? And if you see my cross-examination of Nelson, if anybody was there to watch, you would find out that that wasn't true in the least.
It did seem like it was a very intense interrogation.
Well, they made her throw up.
Yeah, we saw that part.
How much more intense can you get? I mean, and they asked her the question why 363 times in the snippets that they showed.
Yeah.
Not the entire 6-hour interrogation, okay? And if she knew anything, she would have said it when she was being coerced into giving statements. So that interrogation did not present any incriminating evidence. So you're stuck with an entirely circumstantial evidence case. Nothing in Dateline about the ordering of the coercing for purposes other than to kill Mary Yoder, like the letter of intent did it for horticultural purposes, like the fact that Mary made the mulch, the bill used to grow the marijuana in South Carolina, where you use coercing. I mean, all this came out in the trial. Okay, all of this is there in front of the jury. Okay. Who rushed to a judgment based on an Allen charge that was premature so that they could compromise and get out of the building. That's basically what happened in this case.
Do you so explain how this is going to work? Because I know the Observer-Dispatch covered a portion of your, and I have a copy of it as well, a potential appeal.
We have a rough draft of it. Anyway.
I understand. So tell me, obviously, at sentencing, you're going to ask for what?
Yeah, what does she face, and what are you going to ask?
Correct.
Her?
So, are you going to make a motion to have?
I'm entitled to make a motion before sentencing.
Before sentencing,
the judge under the criminal procedure law to set aside the verdict.
And you will do that?
I will do that, and I will outline in that motion all the potential grounds that an appellate court will look at in this case, okay?
Got it.
And that's all a horse can do at this stage.
Now, tell me, are you handling the appeal before the appellate court? Because I'm beginning to hear rumors that you're not handling that part of the case.
I don't know. That hasn't been decided yet.
Okay. All right. And so what you sent out to the media and what the OD referred to was what your appeal will look like as it's growing, as you're building it, what your appeal will look like before the appellate court.
What I sent out were the grounds under the statute, under the motion, under 33030, that states that there's appellate grounds on the record that an appellate court will look at to reverse the conviction.
By the way, we're talking to Frank Policelli. Frank was the defense attorney in trial number 2. You saw some of his arguments.
Trial number 2 never did get the attention that trial number 1
did.
got. And I talked to the people from Dateline because they said they could have done a 3-hour version of this because they rushed into the last 15 minutes the second trial, and they didn't do it justice, in my opinion.
I almost feel like they did everything, and then they got up to the trial, and they just rushed it.
Exactly.
It felt that way, yeah.
They had time constraints.
I felt like there could have been and next week we'll get into the trial. That certainly could have been the case.
But like I said, you know nothing about the defense theory of all the other reasonable hypotheses that point to innocence that were never disproven by the prosecution.
Right.
Okay? You got to remember, in an entirely circumstantial evidence case, the prosecution has the burden to prove every hypothesis that the defense puts forth is unreasonable.
Yeah.
Every circumstance.
Is there any part of your case that you look back on and say, I wish I had done this, or I wish I hadn't have done this? Anything that you've second guessed yourself?
No, not at all. I did everything that I wanted to do in that case. We presented enough reasonable doubt that a fair jury would have thrown this case out in a heartbeat.
Yeah. Did you feel the same way Chris Pelly felt? Because Chris Pelly felt that he expected after the first trial to have a not guilty verdict come back within a half an hour.
I love Chris Pelly. He's a very adamant, excellent young lawyer, but I've been around long enough to know you can't trust juries around here.
Okay. All right. And you feel I had said just a few minutes before you came on the line that for me, based on everything that I know, and I've dug into this case and everything that I've learned from this case, I still don't believe there's enough evidence to come back with a guilty plea. And if you can't do it on murder, how do you come back on manslaughter? If not just the fact that, well, it's a lesser charge, I think like we're doing her a favor. But that's a 25 years in jail favor, by the way.
You hit the nail on the head. They compromised. It's clear they compromised because there was absolutely no evidence in the case of any intent to commit serious physical injury when the entire theory of the prosecution from day one is intent to kill. Then they come up with this fairy tale of, well, geez, maybe she poisoned him with the alpha brain, that there's no evidence that he had any codeine in it, and maybe she just wanted, once she found out he only got sick, maybe she changed her intent to only try to seriously physically injure her. But for what reason?
Okay.
No motive to do any of this.
I have some more questions. Would you mind, do you have time if we were to call you back? I got a news break at the top of the hour. Could I get you back on at 10 after 7? Because I just want to throw some additional questions at you.
Yeah, call me back.
All right, we'll get you right back, and we have your number and all. Everybody, hold on. I'm going to give you to Davey just to make sure we get your correct number, because Frank just called in here this morning as he was hearing, and that's what I was going to say is it must kill you, just probably like it kills the DA's office, as here you have this group of people and people calling in, and we have absolutely zero legal background. However, I probably have more legal experience than the rest of you because I spent about 8 years in family court. So I believe that I've earned my honorary legal degree here. The fact is, we know really nothing. And it must frustrate, like, Frank and even the DA's office. They're like, what are these people talking about? Well, guess what? We are the people. who potentially, please don't ever, I don't have time for it, could be on the jury, right? We are the people who make the decision. So you can discredit us till the cows come home, but at the end of the day, we could one day be on a jury and having to make those very decisions. That's what our system is built upon. Got a break.